So, due to the unfortunate circumstances that caused Lillian Garland to really be in an unfortunate financial spot, sorry, my dog just got. She ended up deciding to discuss with the California Department of Fair Employment and Housing about her situation and what had happened with her her job, and they had actually they let her know that CalFed's action was actually legal and encouraged her to file a claim. And so she chose to file a lawsuit against CalFed, and she claimed that her previous employers violated Section 12945 parentheses B parentheses 2 of California law, which had been put in place only a few years earlier. And so that law is actually very important in this case. That law had been passed in response to the federal government passing the Pregnancy Discrimination Act of 1978, which they proclaimed was relevant with the Civil Rights Act of 1964, and it states that every woman is entitled to up to 4 months unpaid leave without losing her job for medical disability caused by pregnancy or childbirth. So once Congress passed that law, California passed the 12945 parentheses B parentheses 2 law in response to that, which pretty much just further ensures that any employer cannot refuse to allow a female employee affected by pregnancy, childbirth, or related medical conditions, and that they are protected to have the period should not, they are protected to have that allotted period of time to do so. So that's what she claimed, that's what she filed her claim under, and said that her CalFed's actions were violating those laws. So in response, CalFed chose to go into an equal treatment argument, and pretty much argued that requiring employers to give disability to pregnant women is a form of sex discrimination, singles out women for preferential treatment. They stated that if disabled men do not have the right to reinstatement, they said neither should women who have just had babies. So they went into they more so went and said that the law itself was violating the Civil Rights Act of 1964, and saying that it itself was actually promoting sex discrimination instead of vice versa. In Miss Garland's argument, she had she supported preferential treatment, and pretty much believed that it's not that men and women should be treated equally or alike, it's that they must have equal opportunity to succeed. And when it comes to pregnancy, equal treatment honestly just means inequality for women. Pregnancy is not something that could really, well, not pregnancy, but childbirth itself, the process of childbirth and pregnancy itself cannot really be impactful on the lives of men. In some situations, in most situations, pregnancy itself all the time cannot. And so it's saying that by saying that they deserve equal treatment between the sexes, that they're pretty much just saying that, oh, the fact that women get pregnant, that's your own fault. That's not equal treatment. You guys both don't get medical leave, or you both do get medical leave. And these arguments really did surprisingly split the beliefs of a lot of legal scholars and feminist groups. A lot of feminists obviously did support and agree with Lillian Garland and her proclamations, but some feminists were worrisome over the details of passing legislation of this stature. And they argued that protective laws sometimes have more costs than benefits. They were very worrisome of the potential consequences that would actually affect women in the future. And those fears were definitely very valid, because they saw a fear of further inequality happening later on that would cause detriment if there was a protection of pregnancy. So there was a lot of divisiveness, there was a lot of confusion, and there was a lot of people unsure of which side to support. It was a very complicated issue, and it wasn't taken lightly. And so it's made its way through the California judicial system, and then it eventually made the Supreme Court, who in turn, they actually upheld the validity of the California Government Code Section 12945B2. So they upheld that law was correct in the situation, that Lillian did experience sex discrimination in her case. And they pretty much believed that a law setting a minimum leave for pregnancy disabilities did not on its face discriminate against men or conflict with the purpose of Title VII of the Civil Rights Act of 1964 as amended in 1978 by the Pregnancy Discrimination Act. So they believed that CalFed's actions did violate the Civil Rights Act of 1964, and so they believed that preferential treatment was the best way to go about it. And the significance of this case is that it really did not only help women of every socioeconomic status, of every race, every demographic, but it really specifically fought for women of lower socioeconomic statuses that took part in jobs like waitressing and things that weren't like managerial positions or like, very like just very powerful positions. It was definitely women that kind of were hourly or, jobs like that. And so often women in like restaurants and things like that would just, if they got pregnant, they would just be like, okay, then I'm fired. That's just the assumption that you have to have. So this law really protected those women and made sure that they were able to return to work just even if they were pregnant, and that wasn't a fault. That wasn't something that was negative about them. They should be able to have the right to return to a job. It's not their fault that they're pregnant. So it really specifically helped women of those of lower socioeconomic statuses that were unable to really like just return and be able to go to those jobs. So it was a really influential case, and it honestly was really important for protecting pregnant women's rights. And I think that Lillian Garland was really strong to be able to go through all of those things and to be able to go to the Supreme Court case. And she was the mother of 2 children, and it really was an unfortunate situation, but it really influenced the future for the better.